guess we'll go ahead and get started.
My name is Dan Ennis, and I'm the president of the Health Law Association here in Washington. Today we have the privilege of presenting Howard T. Wall, who is a graduate of this law school from 1983 and currently the senior vice president, general counsel, and secretary of Capella Healthcare in Nashville. He also, in terms of some professional affiliations, is a member of the ABA House of Delegates, former president of the ABA Health Law Section, current member of the governing council of the ABA Health Law Section, and an editor on the BNA Health Law Reporter. He started out at what's the firm name? Waller Lanston in Nashville from 1983 until 1997, and was in-house at Providence Healthcare for 8 years after that, and has been at Capella ever since. So if y'all please join me in welcoming Mr. Wall.
Well, thank you, Daniel, for that nice introduction. And I appreciate all of you for coming out today. I recognize it's been a number of years since I was in this big courtroom. It's changed a little bit since then. It looks a lot nicer now. It's not nearly as dark and imposing as it used to be. And given the small group, I may deviate from some of my formal remarks to make sure we have plenty of time for some interaction along the way, some discussion, because I want to address the things that you think are significant. But I do want to spend some time today talking about the topic at hand, which is the role of the in-house attorney, in-house counsel in a highly regulated industry. Today's topic is something that I deal with on a daily basis. And to provide a backdrop for today's topic, I wanted to take you to a small town in Southern Virginia. It could be just as well a small town in Tennessee or Texas or Illinois or Washington. The location is very ordinary, a very ordinarily appointed classroom on the main floor of a medical office building attached to the regional medical center. Into this room they begin to trickle in, taking a plate and filling it with a meal prepared by the hospital's dietary staff. One after another, the most highly educated and in many cases the wealthiest people in this county of 80,000 residents go through the line and take their seats along the tables that are set up classroom style. They come from all over the place. A few come from the small town, a few come from big cities trying to escape from the urban sprawl, and many come from other parts of the world. They've all taken a different path through college and through medical school. About half of them are in primary care, health care, and the other half are in very highly specialized field that required a number of years of fellowship training and residency even after medical school. Despite the diversity of ages, gender, religion, politics, national origin, and education, all of these have one thing in common: they are all medical doctors. These individuals became doctors for lots of reasons. Some of them are driven business people and became doctors to make a lot of money. Many of them became doctors because they really want to do something to help people and help society. But many of them probably became doctors because they were just very bright individuals in math and science, and our educational system tends to encourage people with those skill sets to go into the medical profession, and that's not necessarily a bad thing. Yet despite of these very diverse reasons for selecting medical school and becoming doctors, there is one reason that they absolutely did not pick when they decided to become doctors. Not a single doctor in that room went to medical school because they wanted to be a part of a highly regulated business. Not a single one of them looked with envy on their friends and associates who work in public utilities and insurance companies and concluded that they too wanted to spend the rest of their lives in businesses in which every aspect of what they do on a daily basis, if not an hourly basis, is regulated and evaluated by laws, rules, regulations at the federal, state, local, and quasi-governmental level. In fact, these doctors are pretty representative of doctors across the country. Not only did they not desire to be in a heavily regulated business, but they went into medicine perhaps instead of business so that they could be autonomous and independent individuals. They wanted to be able to use their superior intellect and problem-solving skills to fix things. Yet there are, in this profession, as much as 30% of the time they spend is in dealing with administrative work, paperwork, and other regulatory requirements. The cost of the practice has grown dramatically over the last few years at a rate that far outpaces inflation. They are forced to to hire experts in coding and in billing, because mistakes in coding and billing can get them significant fines and penalties from the federal government. They are required to hire consultants and lawyers to maintain compliance with the Hipaa law, a well-intended law that's designed to keep medical information private, but which contains so many complex and burdensome provisions that the average physician is wholly incapable of following the complex set of rules and requirements without hiring expert help. And all of this is going on at a time when Congress every year must act to keep them from getting an up to 10% cut in their reimbursement. So in the case of doctors in America, it literally takes an act of Congress to keep their pay from being cut every year. So into this classroom I walk. You see, I am the general counsel of the company that owns the hospital. It's my job on this particular evening to explain to these doctors that in addition to all of the other burdensome regulations, the federal law also dictates that they must maintain staff privileges at our hospital, and if they do so, they will be required to come in to the emergency room to take care of patients who need a specialist in their particular area. Under the EMTALA law, the Emergency Medical Treatment and Active Labor Act, every hospital in the country with an emergency room must take care of patients who come to the emergency room regardless of the ability of the person to pay for the services. And the government expects that the services that are generally made available by that hospital to the public will also be provided in the emergency room. And actually, the idea that in America patients who come to the emergency room should be able to get taken care of within the capabilities of the hospital does not sound like a bad thing. We are not going to tolerate a situation in which a patient comes to the emergency room with a life-threatening condition and then gets turned away because he doesn't have any insurance. That only sounds fair. But let me tell you how the doctors feel about it. Worked to death, making less every year than the year before, and burdened with administrative paperwork, now you're going to tell them that they have to be on call a certain number of days each month, perhaps 5 days, perhaps 15 days. And when they are on call, they must be ready at any time of the day or night to leave their patients in their office, to get out of bed, and to come into the emergency room to take care of patients, many of whom they have never laid their eyes on, before pulling back the curtain on the emergency room unit. They are expected to perform whatever medical treatment is needed by the patient in order to stabilize their condition, regardless of whether they are in a position to pay for the services or not. And to top it off, they do not receive any immunity from litigation when they are called to the emergency room. Quite to the contrary. Doctors are actually more likely to get sued for the services they provide in the emergency department for patients they have never seen before than for all the rest of their patients with whom they have an existing relationship. It is to this audience that I have to present the requirements of this law, explain our company's policies on complying with the law, which they view as just more government red tape and burdensome requirements they have to follow, and help them understand how all this affects them within their practice. And there's little that one can do to prepare to answer questions from a group of angry doctors. And for those of you who have doctors in your family, please do not take this in a negative way. Doctors are wonderful people, but in this setting they could be very contentious and troublesome. The cold stare awaiting an answer that could only be delivered by the legendary Roger Groot in a first-year criminal procedure class, or the probing questions of Professor Calhoun or Murchison in a moot court competition do not compare to the looks and the questions that you get from these doctors in a situation like this. Yet this one event is just an example of the challenge that I must face every day, as I must work with individuals, doctors, nurses, accountants, senior managers who do not get an education because they love to be regulated, and they do not choose and did not choose to have all their major decisions evaluated by other third parties. Our legitimate business objectives is to help them navigate through the difficult world of healthcare regulation and regulation of other businesses and achieve the business purposes that they want to achieve. So as we leave the small southern Virginia city and return to the much more elegant surroundings of this moot courtroom, I'm prepared to address this question of what is the role of in-house counsel in a highly regulated industry setting. And I want to accomplish three things in the time that remains today. I want to provide a framework for understanding regulation of business in America generally. I want to talk specifically about regulation in the healthcare industry. And because so many of you have a specific interest in health law, if there had been a broader group, I would have probably kept it more general. But because there's enough who have an interest in health law, I'll focus on those issues. And then finally, I'll end up and provide 4 and 5 important considerations for the in-house lawyer in a highly regulated industry. And in the conclusion, I'm happy to answer any questions and answers that you might have. I can stick around for a few minutes after the presentation to do that. The regulation of business in America, as we know, is pretty extensive at a federal and state level. It is vast and complex. There is a significant body of law and regulatory schemes that applies to all businesses. And then in certain industries, there are varying degrees of specialized regulation for those businesses. The laws and businesses that apply to all corporations in America are the types of things you study in business law class in law school or in undergraduate school. As all of you know, the regulation of business in America starts with the Constitution. Obviously, before the Commerce Clause and other provisions of federal law extended so heavily into business, it was primarily a matter of state regulation. And in fact, many businesses, small businesses, continue to be primarily regulated at the state level. And I will certainly review some of those, but we'll focus primarily on the federal laws. The kind of basic overview of state law or federal laws that apply, or state laws that apply to all businesses, of course, are general corporation laws that affect all business organizations, corporations, partnerships, limited liability companies. Every state's law is different. Many states have similar laws based on the model acts, but every state law has different laws. And as many of you know, states like Delaware have a favorable business climate, so many corporations choose to organize there. But a patchwork of laws, again, is one of the burdens for any lawyer in industry and in business, not just in health law or a regulated business. State consumer protection laws apply to all businesses. State local tax laws apply to all businesses. Local business licensing requirements apply. State laws that mimic federal regulations, such as antitrust laws, securities laws, environmental protection laws, employment laws, are all at the state level and often mimic or duplicate federal initiatives in these areas. And of course, the common law, state laws that deal with most business disputes like contracts and torts and other issues within business, are out there that must be addressed by all businesses, not just heavily regulated businesses. While many businesses can exist and only worry about these state and local laws, for the larger corporations and for multi-state corporations, the breadth of federal laws must also be considered and examined. And I will not go into detail on any of these laws, but I'm just going to kind of list some of the major legal regulatory schemes at the federal level that all businesses have to deal with. Obviously, the securities laws and access to capital is important for most large businesses. Wage and hour laws and other labor and employment laws at the federal level. Workplace safety, OSHA requirements, environmental protection laws, antitrust laws, credit protection laws that extend to a broad range of agencies, just to name a few that apply to all businesses. And why did I go through that detail about just general business regulation? It's to say that despite the breadth of these laws, I do not consider any business that has to deal with all of those laws heavily regulated. That's just standard fare. Heavily regulated industries are those in which the Congress has decided there is a legitimate public policy purpose in imposing additional layers of regulation on those businesses. There are some compelling public policy reasons for that, and I'll give you some examples of that. The banking industry was once heavily regulated in this country. We did something called deregulation in this country for the banking industry. And in response to deregulation, the banking industry has gone nuts. And so what we're going to have happen now is likely a re-regulation of the banking industry. But that is an area that has been heavily regulated in the past, as an example of a regulated business. Food and drugs. Who could question whether it's appropriate to regulate food and drugs? The American people expect safe food and safe drugs in the market. That is what their expectation is. So that's an example of specific regulation that is industry specific. Public utilities, another example of a regulated business. Federally regulated, certainly state regulated, but primarily at the federal level. But I would argue that in the context of all these regulated businesses, the most heavily regulated business in this country, in my opinion, is the healthcare industry. And this is where I'm going to turn my attention now for the next few moments. Why healthcare? Well, newsflash. Last night, the House of Representatives passed an $819 billion stimulus package. It contained $544 billion in new spending. Of that new spending, $153 billion is in the healthcare industry. It includes improvements in Medicare, Medicaid programs, IT programs, and other initiatives in healthcare. But basically 28% of the new spending authorized by Congress last night, if it becomes law, will go into the area of healthcare. This is at a time when 17% of the gross domestic product of the United States is in healthcare and growing every year. So almost 1 in 5, 1 in $6 produced in this economy are within the healthcare sector. And in today's economy, healthcare is creating jobs compared to other sectors which are shedding jobs. Almost 100% of the healthcare that is provided in this economy and consumed in this economy are provided by Americans to Americans. It is a area of industry where most of the consumers are buying it within the country, and most of those providing it are corporations or individuals based in the country. Certainly in pharmaceuticals and other fields, medical devices, it's an international business, but much of the healthcare spending is American spending. High-skill, high-wage jobs are being produced in healthcare. And in the future, we have a huge growth horizon because of baby boomers. So why would Congress spend this amount of money in healthcare to boost the economy? Because so much of what's going on in the economy is already in the field of healthcare. With each dollar of federal spending, though, comes a further basis for federal regulation of the healthcare industry. For those in my business, and believe me, there are still some who want to complain about being regulated, they just simply need to get over it because healthcare is heavily regulated, and the attitude needs to be trying to understand these regulations and to apply them in the business setting. The regulation of the healthcare industry is a patchwork of state, federal, and local laws and regulations, old and new, from common law principles that date back to the foundations of our legal system to theories that have emerged only recently. The industry also has substantial self-regulation with the practical effect of government regulation. And I'm going to go through some of this patchwork, and what I would say kind of as a general point about healthcare regulation is very few regulatory schemes go away. We have many regulatory schemes that are formed and put in place. Eventually, additional layers are placed on providers and individuals and businesses in healthcare, but the old schemes don't necessarily go away, and I think you'll see a pattern of that. Let me first look briefly at state regulation, and I'm not going to try to cover every issue in state regulation of healthcare. I think I saw a health law textbook on one of those desks that probably does that, so I won't attempt to recreate what happens in that course. But kind of a fundamental principle is that prior to the Medicare law in 1965, virtually all regulation of healthcare was at the state level. And the basic fundamental notion under state law, which is certainly a constitutional principle that states are to protect the health and safety of their citizens, is through licensure laws. Licensure of hospitals, physicians, other providers who are taking care of patients, and an imposition of certain basic health safety requirements on those licensed individuals and organizations providing health care to the public. And that's kind of a fundamental concept of state law, is to protect the public, make sure that those holding themselves out to provide these services to the public are well trained and well prepared to do the job. There are additional laws at the state level, though, that go beyond that. Many states have something called certificate of need laws, where states have decided that as a matter of public policy, it is going to take state approval for example, hospitals and facilities to expand beds, expand services, to make capital expenditures. I mean, it's centralized health planning, if you get down to it, by the government of healthcare activities. And you know, the great thing about it, if this is a gold mine for lawyers, it's just an incredible thing for lawyers in states with CON laws, because for any hospital or other provider to accomplish their business purposes, they have to go to a politically appointed state agency and get approval of the project. It is a lengthy, cumbersome project, involves consultants, lawyers, but it's another example of state regulation of healthcare. The interesting thing about this, and I'm going to kind of deviate for a moment because I think it kind of puts in perspective the point I made earlier, these laws were first federally mandated because they were seen as the way to control healthcare costs, the growth of healthcare costs. The federal government completely abandoned this approach and went with something called the DRG system, or prospective payments, for Medicare to contain healthcare costs. So by the early 80s, the federal government had abandoned this notion of centralized planning. The states, in many cases, over half the states still have laws on the books with this type of planning in place. So even though 25 years ago the Fed said, we don't need to do that anymore, the states have continued the CON laws. Medicaid is a state program with federal funds heavily supporting it to provide health care for indigent patients. Peer review statutes at the state level provide protection to physicians and others providing peer review in accordance with hospital medical staff bylaws to investigate claims of impropriety, for example. And there are presumptions under peer review statutes that as long as individuals are acting in good faith, they are provided with immunity from prosecution. We have state insurance regulations, although it's important to note that the vast majority of health benefit plans in this country are employer-sponsored plans that are governed by the federal law, ERISA law, and are not subject to state regulation. Nevertheless, you have state regulatory laws for insurance. State contract law, which is different in every state again, mostly formed by the common law, supported also by statutes, are very relevant to healthcare providers. The regulation of not-for-profit corporations, again, we could spend an entire course on this topic. 80% approximately of hospitals in this country and a number of other providers are set up as not-for-profit corporations under state law, are tax exempt for federal purposes, and have access to capital through tax exempt capital markets. And as a result, they are subject to state regulation under the not-for-profit laws, which are often governed by corporation agencies, secretaries of state. But in recent years, through some old common law doctrines like charitable trust doctrines, the state attorneys general have also got into the act of regulating not-for-profit hospitals. Torts and medical malpractice, again, healthcare providers are subject to redress in the court system if they cause injury or harm arising from negligence or from acts of misconduct. Recent attempts at the federal level to what I refer to as federalizing the tort system and depriving the states of the right to have jury trials to deal with these medical malpractice situations have failed, so still tort law is, as it has been since the foundation of this country, a matter of state law, not a matter that Congress can regulate. And finally, we have things at states called corporate practice of medicine laws, doctrines that say only licensed individuals can provide health care services. Now, that law has been interpreted by some states and courts to say that a hospital could not employ a physician. Now, how counterintuitive is that? But yet that's a common law doctrine that's stayed at many states that continue to operate. Now, I talked about general corporation laws. I've now talked about state regulation of health care. And for those of us in the health care practice, what we've talked about is nothing. This is not even where we spend any of our time, because the real issue in health care is federal regulation of health care. So let me breeze through an overview of some of the federal laws that apply in the health care area. And again, I'll repeat it because I think it's worth noting that why we're here is because in 1965, the federal government started paying for a lot of health care in this country. Now, many hospitals and providers find that as much as 50% of their business or more is from Medicare, is government-funded, reimbursed business. Now, of my bottom line, probably much less than 50% emanates from Medicare spending. But in terms of the actual services that I provide as a hospital, well in excess of 50% is provided to Medicare patients. Because of this heavy involvement of the federal government, they have used the Medicare law to impose a vast array of regulations on healthcare providers in the healthcare industry. The first law, which is sort of the granddaddy of healthcare regulation for healthcare lawyers, is the portions of the Social Security Act known as the Anti-Kickback Laws. These Anti-Kickback Laws prohibit the willful solicitation, offer, acceptance, or payment of remuneration, essentially to induce referrals. These laws are punishable by fines of $25,000 per violation, but more importantly, by criminal sanctions and by exclusion from the Medicare program. This is a criminal statute, and compliance with it is very significant. Because the laws are so broad, though, the federal government and Congress has authorized that a series of safe harbors be established to protect activities that are unlikely to result in fraud and abuse, but which may technically be in violation of this very broadly worded statute. Since the passage of the safe harbors beginning in the late 1980s, essentially an entire industry of healthcare lawyers has arisen to do nothing but to help providers navigate through the very difficult regulatory scheme that is reflected in this anti-kickback law and the safe harbors. Really over the last 2 decades, beginning in the mid-1980s and probably continuing up until the last 7 or 8 years, the anti-kickback law was the primary focus of healthcare lawyers who were representing clients in this field. But because it's a criminal statute, they're very hard to enforce. So by the 1990s, Congress took a different approach to help prosecutors and enforcers, and they adopted what is known as the Federal Anti-Referral Law, or the Stark Law, named after Congressman Pete Stark. And the Stark Law is really a strict liability statute. If there are financial relationships between providers or among providers, unless those financial relationships fall into very narrow exceptions, then there are very serious penalties that are involved. Over the last decade, the shift of government regulation, the shift of enforcement activities, and the shift of what health lawyers do has really been away from the anti-kickback statute and more to this Stark Law that's out there. Again, making sure every arrangement that's a financial arrangement in the healthcare industry fits within one of the Stark exceptions is what lots of Stark law of healthcare lawyers spend all of their time doing. And I'm not going to go into a great deal about all the other laws. I'm just going to kind of enumerate some of the other federal laws that are out there. We have the False Claims Act. The False Claims Act was enacted during the Civil War to deal with profiteering, but it is now used in the healthcare industry because it allows for fines and penalties for any mistake or false claim that is presented to the federal government. I've already mentioned the EMTALA law, the anti-dumping law that regulates conduct in the emergency room. I mentioned the Hipaa law to protect healthcare privacy issues. The Healthcare Quality Improvements Act is another law passed in 1986 which encouraged peer review at the state level. Now remember, we already have some state laws dealing with peer review. Now we have a federal law dealing with peer review and providing immunities. It also created the National Practitioner Data Bank, where information about disciplinary actions to providers is now reported and is publicly available for certain folks. We have Irs Tax Exemption issues that I alluded to briefly that are, in addition to the state initiatives to control and regulate the not-for-profits, we also have the IRS looking at the not-for-profits, and we have Senator Grassley every year having hearings about what the not-for-profits are doing and threatening to take away their tax-exempt status. There's a vast body of law surrounding Medicare certification, reimbursement, and now the Medicare Part D program passed during the Bush administration, which is the most expansive growth in the federal Medicare program since it was enacted in 1965. Without equal, this federal Medicare program and all the regulations associated with it are the largest body of laws that deal with healthcare providers. But I'm not through. We have antitrust laws, and I promised Jeff Miles I'd mention antitrust laws. And the antitrust laws, most notably the Sherman Act, the Clayton Act, the FTC Act, deal with a range of issues. For example, price fixing, division of markets, concerted refusals to deal, monopolizations, attempts to monopolize. These are areas which have been very active in healthcare over the years. Now, there's no question about it, and politically this is one of the issues that is affected by elections. There's been a notable decline in antitrust enforcement activities over the last 8 years. All the experts are predicting an increase in antitrust regulation in healthcare as well in the years to come under the new administration. Labor and employment laws and some particular laws that affect healthcare providers. And there are many other regulatory schemes that I will not go into. Now, we are not through because we have now quasi-governmental agencies. The Joint Commission, formerly known as Joint Commission for Accreditation of Healthcare Organizations, now simply known as the Joint Commission, is out there to accredit facilities. Hospitals that are accredited by the Joint Commission are deemed to be certified to be providers in the Medicare program. So that's why, even though the Joint Commission is not a federal agency, it is a quasi-agency because it has an important capability to accredit facilities and get them in the Medicare program. The list of requirements for Joint Commission comes in a large book for each of the entities that we have to be familiar with because it changes annually, and it dictates how a hospital is to be governed, for example, how the medical staff is to be organized, what rights you have, how you deal with conflicts among leadership within the facility. It also has quality standards, credentialing standards, incident reporting standards, and that is not to now deal with a new vast system of reporting, HCAPS, core measures, other reporting requirements that will be publicly made known that will affect a reimbursement of a provider. With that said, healthcare providers and health plans are very heavily regulated. Unlike banks and public utilities, healthcare laws do not flow from a single source and oversight scheme, such as many of these other industries. The laws are often difficult to understand and at cross purposes. Regulatory compliance officers, attorneys, and risk managers in most healthcare organizations are stretched to the limit in keeping the organization in full compliance with all applicable laws. Effective legal representation of healthcare organizations can only happen if attorneys recognize the big picture of all of these regulatory schemes that are in place. Depressed? Confused. Welcome to my world. This is what the role of the in-house lawyer is to be in a regulated industry. And let me give you 5 important considerations as I conclude today. Number 1, know your client. Recognize that the people that you're dealing with in my business, the doctors, the hospital administrators, the accountants, did not go to school to be regulated. That is not what they are all about. They went to school to be in business, to be in a profession. They did not go into school to be told what to do at every turn. So you make your job harder unless you try to look at the world from their perspective. Recognize their frustration in the heavy regulation, but also make them aware of the absolute necessity in complying with the legal requirements that are out there that are in place in their industry. Second, recognize and embrace the legitimate public policy purpose behind the regulations. It's easy to criticize, and absolutely I did it today, the vast patchwork of laws that they're often conflicting and confusing that we have to follow. But they are, in most cases, well-intended laws. Hipaa was well-intended. Hipaa created billions of dollars of cost and burden on the healthcare industry. It was a well-intended law. It has just been implemented in a way in which the cost and the difficulty far exceeds the benefits, in my opinion. But for the most part, we have to look at the legitimate purpose, because what will happen otherwise is a pattern of constantly trying to be critical of the law and avoid the law. And in many cases, healthcare providers are always falling over into the gray area of activities that can eventually go off a cliff if they are constantly trying to resist the laws that apply. So, as I said, embrace them, try to recognize the legitimate public policy purpose, and try to comply with them in a way that makes sense for your business. Number 3, don't be afraid to get help. most in-house lawyers must be generalists, and so they will need to seek outside counsel in certain areas and responsibilities if the need arises. I have a great deal of experience from private practice and now 10 years in-house that I can rely upon, but there are certain things I don't deal with. I don't deal with tax laws. I don't deal with environmental laws. I don't deal with ERISA. I do not deal with antitrust, and I do not deal with complex litigation. These are areas where I need experts. And the best thing I can do is when I see an issue, when I spot an issue, is pick up the phone or send an email and get the right person engaged to help my organization. Number 4, don't allow yourself to be compartmentalized. Don't get forced into a silo, forgive the use of the overused business term. In these regulated businesses, it's extremely important to be involved in all aspects of the business. Legal issues abound throughout the organization from top to bottom. Don't sit in your office and wait for people to call you to solve their problems. You need to be in business meetings, you need to be out spotting issues within the organization and try to address the problems before they arise. And I like to be in our monthly operations review meetings where we look at the operations of all of our 14 hospitals. We're a small startup company. And in these meetings, I can spot issues of legal concern. But more important than just spotting issues is that I cannot be blamed on all the company's problems. And you would be amazed at how business people can determine that lawyers are fully responsible for all of the misfortune that is happening in the business. I've been blamed for the inability to collect money in the emergency room. I've been blamed for poor volumes at our hospitals. I've been blamed for a lack of the flu in the country, which I don't understand that one. But lawyers can get blamed for a variety of ills if they're not in the room. So as a lawyer in an in-house situation, be in the room as often as you possibly can. And number 5, vow to learn something new every day. In the field of healthcare, with the rapidly changing laws, regulations, something happens every day. Something comes across my modern healthcare daily email or my B&A email every day that is relevant to what I do. And in healthcare, it's important to stay totally on top of the issues and the developments that come across. Well, my time is now gone, and I guess in many ways I'm kind of like the doctors that were in that small classroom in Southern Virginia. I did not necessarily come to law school with an anticipation that I would be advising a highly regulated business. In fact, I expected to be, as I was arguing moot court as a first-year student and as preparing for national moot court competition as a second-year student in this room, which, as I said, looked a lot different, I expected to be in the courtroom, not in the boardroom. On the other hand, I can certainly say that the critical thinking skills and problem-solving skills that were developed in many ways in my 3 years here, what now seems a long, long time ago, are now used in a way that is very meaningful and is very helpful to an industry which is totally dependent on the advice of skilled, effective lawyers at every aspect of what they do. Simply put, in the field of healthcare, business cannot go on without lawyers involved at every step of the decision-making process, from beginning to end. And in that sense, the skills that you learn in law school can be extremely valuable to healthcare or other industries that are highly regulated in the manner that I've described. Now with that, I am now happy to answer questions. Open for discussion. Yes, Joseph.
Yeah, I had a sort of comment question and then another question. I have been dealing with a chronic illness in the last few months. I've seen a lot of doctors, and I'm walking in honestly, big stack of papers to fill out, and they're usually papers I filled out when I was there the last time. And I was at one of my doctor's offices last week, and they handed me this big stack of papers again to fill out. And I said, I just filled these out, and I've just filled them out at all the other offices, and why am I doing this? And they said, the law requires it. And I said, what law? I said, there's no law like that. And she said, well, the way this practice works is you see the receptionist up front, and then when you're waiting in the room for the doctor, a person comes in to collect her payment, and that's the person who really knows what's going on. So she said, talk to her when you see her. So I did, and I said, what's this law that requires you to fill out all these papers? And she said, there's no law. She said, our CEO wants you to fill out all these papers. So I think one thing that happens, and you as much as said this, but I'm sure you're aware of it, is, well, you did say it, is the lawyer becomes the fall guy. If anybody wants anything done, they'll say there's a law that requires this, and everybody believes it because everybody believes that the law is irrational. Right. And I think that becomes a problem for us and for public policy generally. But I think one example of that, to my mind, and you probably disagree with me on this, is Hipaa, because Hipaa, I mean, the preamble is huge. The regulations themselves are fairly substantial, but when you get right down to it, they allow sharing of information without consent for treatment, payment, and operations, which is 98% of what I want to share information for, and also for incidental use. And my feeling has always been about Hipaa is, I mean, sure, you got to have the person, you got to give them the disclosure of your policies and have them sign them. There's a few things you have to do up front. But my feeling is that Hipaa has just been a gold mine for lawyers and consultants who realize nobody understands what this is. They're all afraid of it. And we can make a lot of money out of making this as complicated as possible for people. And I think if lawyers would have approached it more with the attitude of, look, this is particularly after the Bush amendments, this is pretty simple stuff, and 98% of what you're doing already is just fine as long as you tweak it a little bit, and don't worry about it. I mean, the other side of that is my understanding is that there have been about 3 prosecutions, and those were things like selling information on FBI agents and using patient credit cards to make charges. I mean, nobody has in fact been really punished for violating it except in really egregious circumstances. And I guess sometimes I wonder whether we as lawyers do ourselves a disservice by, and I do this too, but by making our clients believe that things are really so complicated and they really need us very badly to deal with these things, and they need to pay us a lot of money to deal with them. And that perhaps we could say instead, look, this stuff isn't that complicated, and just do what you're doing and be aware of these little issues here, and things will be better. So that was one thing that I'd like for you to respond to. The other thing is, I think what people would really like to hear you talk about is how one gets a job in healthcare law, because as you've probably heard, things are pretty grim out there in the job market right now. We have an excellent health law program here. In this room, we've got some wonderful health law students, and they would really appreciate hearing about that.
Sure, let me talk about the first one. First of all, I totally agree with you on HIPAA. HIPAA is just, to me, one of my favorite laws to target because, again, you're right, the law itself isn't nearly as cumbersome as it's been made, but I'm not going to blame just the lawyers on this, because I think what we have a lot of are people, administrative people, who have heard that HIPAA requires certain things, and then they take it to a ridiculous extreme without really consulting the lawyers about whether it applies or not.
Fair enough.
Because you're right, I get frustrated when I go to doctors' offices, have the same experience with filling out the forms, which gets into the whole other issue of why it's really important we need electronic medical records in this country, and we need it now to eliminate a lot of this. But in the area of HIPAA, people are probably, because of lawyers, fearful about the consequences, so they've gone to these ridiculous extremes. My own HIPAA story is almost unmatched. My 87-year-old mother had a fall a few months back, and I am summoned to come to the emergency room at large medical center in Nashville. And I go into the emergency room with her. Fortunately, she's fine, she's nothing broken, but they need for her to provide her list of medications. So she proceeds to reach into her purse and pull from it the many times folded over piece of notebook scratch paper on which, in the best efforts that any 87-year-old can muster, has written out all of her medicines and her dosages and how many times a day she takes them. And let's hope she's written it down correctly. And is preparing to hand this to the person who's doing the history and physical in the emergency room as the authoritative list of what she's taking. And I simply say, well, why don't you simply go to that computer over there and pull up the list that the outpatient department gave her 2 weeks ago when she had an outpatient procedure in the other wing of this building. And I was told by that clerk they could not access that because of HIPAA. Now, I'm thinking, that is the most extreme, ridiculous example of where this is healthcare operations. If anything is treatment or healthcare operations, it's getting a list of prescriptions from another department in your own hospital so that you can use it in treating a patient in the emergency room. And yet they were rather going to take the handwritten piece of paper that my mother carries around with her to her different appointments. So HIPAA is a great example of a law that's misunderstood, misapplied throughout the system. So we have a law that I can argue, I could certainly make a case for a one-sentence law saying there is a private right of action if anyone improperly uses protected medical information or private medical information. One-sentence law, I think, would have been all we needed, and then let the courts handle abuses of the system, but we didn't. We got a very complex, cumbersome bureaucratic scheme for HIPAA, but it's much misunderstood. Now, to probably the more important question about getting a job in health law. My own experience is perhaps interesting. I went to a law firm right out of Washington and Lee, thought I was going to go into litigation, walked into a litigation group meeting the day I arrived and was told that because the economy was heating up, they wanted me to go and do securities transactions. So I was a litigator for about 6 hours, my first day of my legal practice. And then I was moved into the corporate group to do deals. Well, I started doing deals that were, a lot of which were healthcare related, hospital acquisitions, joint venture projects, which in this day you couldn't do, diagnostic imaging centers involving physician ownership in the early 1980s, and some surgery center deals, and started representing hospital companies and diagnostic imaging companies and surgery center companies in the transactional side of things only. Well, when it came out in a meeting that I had actually, as a legislative intern in college before coming to law school, had worked with the House Finance Committee in Tennessee, which had regulated the Certificate of Need law, somebody said, well, gosh, you know what a Certificate of Need law is. Nobody else in the firm knows what that is, so why don't you work with a partner on these CON cases? So as a first-year associate, I started working on CON cases as well as some of these other areas that were involving transactions. Long story short, in probably 1985, after I'd been practicing a couple of years, I heard about and went to a conference that the National Health Lawyers Association, which was a predecessor of the American Health Lawyers Association, had put together on mergers, acquisitions, joint ventures in healthcare, and discovered there was a body of law out there. Now, the point there is, in 1983, when I graduated, very few people were even recognizing that there was a field called health law. Most people were litigators or business lawyers or tax lawyers or labor lawyers, and they happened to have clients that were in the healthcare industry, but none of them thought of themselves as health lawyers. So I came back from that conference emboldened and encouraged my law firm to say, well, why don't we market ourselves as having a healthcare practice? And a lot of the partners kind of rejected the notion, but I convinced them to let us put together something called the Healthcare Working Group in my firm in 1986, where we brought together lawyers of all these different disciplines and had probably half the law firm was doing some work for healthcare clients and was able to form the healthcare practice group. That firm, Waller Lansing, now has one of the larger, certainly in the Southeast, and probably one of the larger law firm, health law practices nationally in terms of number of lawyers involved in the practice. I tell you that story about the way I got into healthcare because I think there's something relevant here. While you have many people who come out as a health lawyer, it may be very valuable and important to initially get experience doing a broader range of corporate activities, a broader range of litigation experiences, a broader range of other activities to give you a broader based background as you move into more specialized areas of health law. And here's why I say that. If a person has an interest in being in-house, for example, then they're going to need a little bit of a broader experience because most law firm, most in-house positions are going to be, are going to be for more experienced lawyers, because most in-house law firms don't have the luxury of training people. And they're going to want to have people that have some general skills in addition to a highly specialized area. As I mentioned earlier, there are certain specialties in health law that I'm going to hire a person who does this all day, every day. I had a question about home health care, Medicare reimbursement and certification last week. So I called my friend at a nationally known law firm, and I said, I've got this question. So later that day, we had the conference call with the home health care certification and reimbursement expert in his firm that does nothing all day, every day, but represent home health agencies and certification issues, reimbursement issues, understands the laws that pertain to those. If you are a law student and you go into a law firm and immediately you are asked to be the home health certification expert and that's all you do, and that's all the perspective you have, you're probably going to be locked into that position and are not going to have the flexibility to say go in-house or do something else because you don't have the breadth of experience. So I guess the first thing I would say is that there will be fewer opportunities in-house right out of law school than there will be after you've had either a few years of experience with a governmental agency or with a law firm. Because most in-house, most corporations are looking for people with some experience. Now, it doesn't have to be a lot of experience, but 2 to 3 years at least for a kind of entry-level position is pretty common for a lot of the in-house positions. And they're looking for people that have already worked in the area and have some experience. I am literally getting ready, in fact, made an offer yesterday before I left to add an attorney in my department to do operations legal work where they work with hospitals, they address questions, they review contracts, they advise them on a range of issues. And this individual has about 10 years of experience in in-house positions doing the very same thing. And that's the kind of person I need because our small company, I don't have a lot of time for training. However, law firms that have great healthcare practices, I think, are the ones that would be open to looking at that skill set. So, long answer, but I wanted to make sure I addressed that. I do think that especially for in-house positions, there's real value in getting some range of experiences if you possibly can, and not be simply pigeonholed into a narrow area of health law. Yes?
You kind of touched on this before about the regulation in the starting late 80s and the 90s. Your diagnostic imaging, these things, sort of deals that you couldn't have done. To what, in your experience in-house, have you seen more of a centralization towards a hospital, towards a hospital system? And what are the sort of specific deals or steps that you've taken that have trended in that direction because of the regulation forcing you there?
Yeah, that's a great question. Yes, I think there are a lot of hospital systems that are multi-hospital systems that have become more centralized to as a matter of compliance and control. Now, many of you in health law classes are probably familiar with the fact that that in the enforcement world, many hospitals and other organizations have to enter into corporate integrity agreements. If they've violated the law, part of the penalty, if you will, is that you have to sign a corporate integrity agreement with the government. And under that corporate integrity agreement, you have to impose certain safeguards, such as training, certain outside audits of activities, for example. And often they require some centralization of approvals, of processes, procedures in order to do that. Our company, just by way of example, on things like physician contracts, all physician contracts of any amount must be reviewed. The contract must be reviewed and approved by a counsel, by a lawyer, either me or someone I've authorized. And after it is executed, it must be signed off on in writing by the operations vice president and by legal counsel on every single physician contract. Now that is a centralized policy pushed down to 14 hospitals because there have been some recent enforcement actions against hospitals who just failed to get contracts signed, renewed, updated, and had a bunch of unsigned, unwritten agreements with physicians. Had to pay millions of dollars and then have to comply with burdensome requirements under a corporate integrity agreement. So we have this centralized system in place, which tends to drive people crazy. But as a system, if I don't give my final approval to a contract until all parties have signed it, then I've eliminated the risk of having unsigned contracts floating around out there. So long answer, but the answer is yes, there are systems in place to do that. But what you also see is there are still, it's still heavily dependent on human beings doing the right thing and getting legal advice when they are looking at some arrangement that they're not sure about to make sure what the legal requirements are. I'll give this as one sort of practical practice pointer, and I don't know how the professors in the room would agree with that, but I've actually discussed this with a friend of mine who's the general counsel for the Office of Inspector General and told him I'm doing this. And that is, if I have a contract or a transaction that the fact pattern outside looking in could be confusing or could look like it might be something inappropriate, then I take full advantage of the recitals in the contract to tell the story of exactly what I'm doing, exactly why I'm doing it. An example of a physician who's employed to do something, and by mutual mistake, certain of the responsibilities were not listed in the original contract, and the compensation for those responsibilities were not listed, and it's after the contract term started, and really the rules are you're not supposed to change the contract in the first 12 months. In some cases, it would make no sense to not change it because of the facts and circumstances. So I basically tell the story of what happened, why it happened, and why we're doing it. That we are not backdating a contract, we're dating it as of the day we're signing it, but here's what happened and here's why we're doing it. So that's just my practical advice as a health lawyer, to frankly get back to the point where the law seems to make no sense. Use common sense, and in some cases just be very forthcoming about what's going on. And my view is when the government regulator comes and looks at the situation, they will appreciate the fact that you're not trying to sweep it under the rug. They'll appreciate your candor in trying to address it. Any other questions?
You mentioned before that the Obama administration thought would increase antitrust enforcement. Are there any other areas that the Obama administration will change health law going forward? Or change regulations?
That is simply one that I've heard, and I was at the Washington Healthcare Conference, Washington Healthcare Summit, the health law section puts on in D.C. every fall. We had an FTC commissioner who was in projecting that as a possible increase. And I've also heard that from some of the people in the field. That's an interesting question. I know there's a lot of changeover right now in terms of the individuals at CMS who are responsible for the Stark laws. It will be interesting to see if there's any change in the approach in that agency. Frankly, the healthcare enforcement's been pretty robust in a lot of areas. I didn't see a huge change in recent years. I will tell you one area that may be not just in the administration, but it could be a change in Congress, is that the Bush administration resisted proposals to outlaw physician ownership of hospitals, for example, specialty hospitals. The Obama administration and the Democratic Congress has supported those measures. So they were actually included in the House version of the S-chip law that passed recently, not included in the Senate version. So that's another area of regulation that you may see increase. I think the more interesting area is going to be like in securities, in some of those areas where literally some of the political appointees in the last few years have gone to great lengths to avoid regulating areas of business, and I think that's where there will be a big shift. But in healthcare, I don't think we certainly did not see a backing off of regulation over the last 8 years. It's been a steady march toward increased regulation that did not stop with the change in the administrations.
Another very practical question. Does the ABA health law section have any kind of listing of jobs or any help with career there? I think the National Health Lawyers.
The American Health Lawyers has in their publication, they have a job section that's in there.
Yeah.
And then the Modern Healthcare occasionally will have some job postings for legal. But I think the American Health Lawyers has a much more robust job listing section than the ABA does.
Some people might come up over lunch.
It might.
Because we're just dealing in such a bad climate right now. But it seems to me health law to be one area where jobs are still growing for all.
I mean, I believe that they will be. I mean, I think it's for the reasons I stated, that you have the industry growing, You have new monies going into the industry, and with every new dollar, there is more regulation, there will be the need. And again, I think there will be a shift toward in-house positions. And part of the reason is cost. And the economics of law firms, you see law firms laying off people. I know that's got to be a concern to all of you. Because, and I didn't spend a lot of time talking about it, for those at lunch we can cover it, the economics of law firms make it impossible for me to use big, top-tier law firms to do routine work.
Yeah.
So that's part of why I'm hiring an in-house person. I will literally pay for the salary and probably save tens of thousands of dollars, if not six figures plus in legal fees paid to outside counsel by having an in-house person. So I think there will be more of a shift toward in-house. I mentioned kind of the areas of expertise, where there are very specific areas of expertise, big transactions, big litigation. That's where I'll pay the top dollars to outside counsel. But to do routine work for the hospitals that comes up on a day-to-day basis, I'll need to either use in-house counsel to do that, or I'll need to go to boutique firms that don't have the same economic structure as the big firms.
Do you do any litigation in-house?
No.
And how many people do you have in your in-house department? And for, I mean, if you can tell us a little bit about those.
Well, I have a grand total of 3. I have a full-time administrative assistant / paralegal who really does the work of 2 people, if you get down to it. And then I now have the in-house operations counsel that I'm retaining. And last year paid out $3 to $4 million in outside legal fees. So outside law firms love me, and that's for 14 hospitals. Now
that small department for 14 hospitals.
Yes, and I could easily grow and expand.
Yeah.
But I think you have some not-for-profit systems probably are more heavily loaded with in-house lawyers. I think some of the for-profit systems like ours have much larger departments. But I think there's been also the notion that in the past that you would try to keep your overhead at the corporate office lower. Well, I think in the regulated industry like healthcare, you're going to see an increase of the in-house departments. That's just my prediction.
And do any of the individual hospitals have in-house counsel?
Not at our company, but in many across the country, and especially some of the not-for-profit hospitals, you'll see dedicated in-house counsel. But frankly, again, with the increasing complexity of the regulations, I think there will be a growth on the in-house side. I think there will be a growth probably on the outside law firm side, but it may be that some of the big firms, this actually happened in the case of one firm, you may see some of the biggest firms stop doing what I would consider routine healthcare stuff and stick with the specialized transactional work, which means there will be opportunities for boutique firms to do this kind of thing and for in-house departments to grow.
One more question, I guess. But we have as you probably know, we have a joint degree program with VCU, the JD/MHA program. And if you had someone apply for a job who had a JD/MHA, would you consider that attractive?
I would think it very attractive. Again, let me put on 2 hats. If I'm in a law firm and I am looking to hire somebody for my law practice, my health law practice, that person would jump out at me. It would be an outstanding ad for my department. As an in-house, where I am now with such a small in-house department, I'm going to say that's a great background for that person, and after they've gotten 2 or 3 years of practical experience, I might be interested in hiring them.
Yeah. Okay.
So no, the question is, yes, it's a big advantage. I think it's the biggest advantage to a law firm situation who perceives somebody who understands the business, because learning the business, as I alluded to earlier, is extremely important in healthcare to being effective as a representative and as a counsel. Well, I've gone past time, but thank you all very much.